This video examines how the New York County Clerk's office was quietly reorganized in 1896 and why a single cross-reference to a registry book special index suggests the change was intentional. The mini-verdict is direct. A parallel index existed to decide legal visibility. The evidence is concrete, an 1896 clerical notation that cites the special index without a public shelf location. We will show how and why this decision separated officials from the legally invisible. By the mid-1890s, New York was not merely growing, it was reorganizing itself. Population pressure, consolidations of authority, and the expansion of urban records demanded order at a scale the city had never attempted. In 1896, administrative routines tightened across Manhattan, and with them came new methods of classification, quiet, technical, and decisive. Publicly, the city spoke the language of progress and transparency. Privately, it refined the machinery that determined who could be proven to exist. At the center of this machinery stood the Hall of Records, a space associated with permanence, verification, and civic memory. Deeds, probate filings, and clerical indices did more than preserve facts. They established reputations. In an era when a family's standing could hinge on a ledger entry, the difference between appearing in the central register and being routed elsewhere was not administrative trivia. It was consequence. The Gilded Age understood appearances. Newspapers chronicled fortunes and social arrivals. Society pages polished names until they seemed inevitable. Yet beneath that public sheen, legal identity depended on filing logic. How a name was indexed, which book it entered, and whether a clerk could retrieve it on demand. The risk of the period was not scandal alone, it was misclassification. A misplaced reference could stall an inheritance, cloud a title, or erase a claim without ever announcing a dispute. This is where the case begins. Not with an accusation, but with a discovery. While reviewing peripheral documents tied to elite properties, a researcher encounters an old cross-reference. It is precise in its wording and unremarkable in its tone. It points to a registry book special index. There is no flourish, no warning, and yet the catalogue offers nothing back. The index cannot be requested. The shelf is not named. The absence is procedural, not dramatic, and that is precisely the problem. In 1896, New York's record-keeping expanded to manage growth. The historical context is verifiable. Municipal reforms accelerated, clerical offices professionalized, and the press celebrated efficiency as civic virtue. But efficiency also creates hierarchies. Central books confer immediacy. Auxiliary indices confer delay. Inheritance law, especially among the elite, relied on immediacy. A name that surfaced only in marginal references existed in practice, but not in proof. The tension of the moment lies between image and decision. Publicly, families maintained continuity. Estates passed, reputations endured, headlines reassured. Privately, clerks applied rules that sorted visibility. No overt erasure was required. The system did not need to deny a name. It only needed to redirect it. When that happened, consequences followed quietly. Documents that referenced ownership without confirming it, wills that gestured toward heirs who could not be formally retrieved, properties that appeared attached to people who were, in the central ledger, absent. If this intrigues you, ask yourself which ledger decided the outcome, and subscribe so you don't miss the next file, leaving a like only if the question itself holds you. What matters here is not yet how the special index functioned, but why it existed at all in a year defined by administrative expansion. The record shows a city intent on order, a press invested in confidence, and a legal culture that equated visibility with legitimacy. Between those forces, a book appears by reference and disappears by access. The introduction ends where the evidence begins. A single notation, a closed shelf, and a building devoted to memory. Its corridors lined with ledgers that look complete until one page points somewhere else. In 1931, during a routine consolidation of secondary materials at the Records Division, Surrogate's Court, a clerk working through unindexed holdings opened a box labeled only as maintenance ledgers. The box was not listed in the primary finding aids and carried no accession number. Visible from the exterior, inside were thin utilitarian volumes used for internal control, checklists, reference sheets, and clerical extracts intended to track activity rather than establish it. Among them was a loose index leaf that did not match the format of any standard probate register from the period. The discovery was dated by its context rather than by any stamp on the page. The surrounding materials were part of a 1931 reorganization effort when the Surrogate's Court quietly reassessed storage practices after space constraints forced the relocation of non-essential items. The leaf itself was thin, cream-colored, and machine-ruled. It bore two vertical columns, typed rather than handwritten. The left column was titled Official Entry. The right column read Non-Entered Private. No court seal appeared at the top. No docket number was affixed to the bottom. The page was not folded into a bound volume, nor was it clipped to a file. It existed as a reference, not a record. The action that brought it to light was ordinary. Inventory. The clerk noted the sheet because it interrupted the expected sequence of maintenance materials. Instead of equipment logs or binding notes, the page contained names. Each name was followed by brief annotations, street references, trust identifiers, or initials corresponding to trustees. Yet none were accompanied by protocol numbers or filing dates. The left column listed names that could be verified elsewhere in the court's registers. The right column listed names that could not be retrieved through the main index. What made the page irregular was not its content, but its placement. Maintenance ledgers were never intended to store determinations of legal status. They existed to support the upkeep of books already recognized as authoritative. The presence of a dual-column index within this category meant that a sorting decision had been recorded in a space designed to be operational, not evidentiary. The page did not claim to grant or deny rights. It merely categorized entries as either official or non-entered without explanation. No interpretation accompanied the sheet. There was no memo explaining its use, no signature authorizing its creation, no cross-reference directing a reader back to a central ledger. Its existence contradicted catalog logic. If a name had an official entry, the protocol required it to appear in the primary index. If it did not, there was no sanctioned category for a parallel listing. The page, therefore, should not have existed as a standalone object. The clerk's immediate action was limited. The sheet was logged as an anomaly and returned to the box. No inquiry was opened. The Surrogate's Court at the time was focused on efficiency and backlog reduction. Extraneous materials were boxed, labeled, and shelved away from public access. The page was neither destroyed nor elevated. It was reclassified as internal. The consequence of that reclassification was practical. Because the page was not incorporated into the official index, its contents could not be cited in open proceedings. Names appearing in the non-entered, just private column remained absent from the searchable record, despite being referenced in relation to properties and trustees. Their association with estates could be inferred through peripheral documents, but could not be formally retrieved through the court's main system. This did not alter outcomes in a visible way. Inheritance proceedings continued. Properties changed hands. Trusts were administered. The page did not intervene in those processes. It sat beside them. Its effect was structural rather than procedural. It documented a path that ran alongside the official one without intersecting it. The existence of the two columns implied a distinction already in use by the time the sheet was created. The page did not introduce a new category. It reflected one. The labels were neutral, administrative, and unadorned. Non-entered, chi. Private did not describe an error or a rejection. It described a state of being outside the central register while still being acknowledged internally. No attempt was made in 1931 to reconcile the page with the main index. There is no record of a follow-up review, no notation of correction. The sheet remained in the maintenance box, separated from the books that determined legal visibility. Its survival was accidental. Had the box been cleared or discarded, the page would have vanished without trace. If the record is legal reality, who controls the record controls that reality. What remains at the end of this discovery is not a conclusion but an object, a thin index leaf, 2 columns wide, resting among tools never meant to decide who could be found, and a quiet confirmation that, at least once, such a decision was written down and set aside. Between 1890 and 1905, New York's legal landscape was shaped less by courtroom drama than by administrative precision. This was the period when consolidated fortunes hardened into structures, trusts, holding arrangements, and layered ownership designed to survive scrutiny. Wealth at that level did not depend on spectacle. It depended on predictability. And predictability, in the Gilded Age, was produced by the record. Old money families operated within a narrow margin of acceptable exposure. Marriage, legitimacy, and inheritance were not simply private matters. They were legal facts that had to be recognized or quietly contained by the system that certified them. The trustee framework, refined in these years, allowed assets to be held, transferred, and insulated without public redistribution. Trustees acted as buffers. Registrars and attorneys became instruments of risk management, tasked with ensuring that only what needed to be proven ever reached the central index. The danger of the era lay in contestation. A single disputed heir could fracture an estate. A misfiled marriage record could invite claims. A publicly indexed name could attract attention from creditors, rivals, or the press. In this environment, the act of recording was itself a choice. What entered the official ledger gained standing. What remained peripheral could be acknowledged internally without being empowered. The press understood this tension. Social columns chronicled lineage and philanthropy, while legal disputes were reported with restraint. When conflicts did surface, they were framed as isolated disagreements rather than structural. Failures. The role of the New York Times was illustrative. Coverage emphasized stability, continuity, and the orderly administration of wealth. The paper reported outcomes, not mechanisms. The underlying processes, how a name appeared or failed to appear in a register, remained outside the narrative. Within that context, registrars and private attorneys performed a concrete action that carried lasting consequences. They limited what became an official entry. This was not accomplished by falsification, but by omission and reclassification. A name associated with a property could be referenced in correspondence, trustee notes, or maintenance materials while being withheld from the central protocol. The result was a form of legal half-life. The individual existed for internal purposes but could not be retrieved by an external challenge. The laws governing inheritance made this strategy effective. Succession depended on proof. Proof of relationship, proof of ownership, proof of standing. Without an indexed entry, proof stalled. Courts relied on the record to establish jurisdiction and legitimacy. If a claimant could not be found in the primary books, the burden shifted. Delays accrued, costs mounted. Most disputes resolved themselves through exhaustion rather than adjudication. This was why invisibility on paper was dangerous and valuable. Dangerous because it contradicted the ideal of transparent administration. Valuable because it prevented escalation. By keeping certain identities off the main ledger, families avoided public hearings that might expose private arrangements. Assets remained consolidated. Reputations remained intact. The silence of the record functioned as a shield. The practice did not require conspiracy, it required alignment. Attorneys advised caution, registrars applied discretion, trustees accepted ambiguity as a feature, not a flaw. The system's language was neutral, non-entered, private, referenced elsewhere, but the effect was decisive. An omission today prevented a contest tomorrow. The real consequence of this environment was institutional. Over time, the boundary between official and unofficial hardened into routine. Peripheral documentation accumulated, carrying just enough information to sustain internal administration while denying external validation. When later generations encountered gaps, they were told the files were complete as filed. The absence was treated as final. In that window from 1890 to 1905, the cost of exposure outweighed the cost of concealment. The record became a tool for managing risk rather than merely reflecting fact. To be visible was to be vulnerable. To be omitted was to be protected. The context resolves into a single image. A clerk's desk at the turn of the century, two piles of paper, one destined for the indexed ledger, the other set aside. Both acknowledged, only one allowed to exist. In 1897, the Hall of Records did not feel like a place where decisions were made. It felt like a place where decisions were filed. The building's authority came from its appearance of routine, counters, ledgers, clerks repeating the same motions until procedure itself looked indistinguishable from truth. That illusion mattered. In the late 1890s, the city's record system was expanding, reorganizing, and tightening. Under that pressure, the most consequential interventions were rarely written as policy. They were delivered as handling, spoken in the tone of maintenance and absorbed into habit before anyone could name them as a choice. The moment we can reconstruct does not survive as a memorandum. There is no stamped directive, no typed circular distributed to desks. What survives is smaller and more telling. A sequence of clerical traces that only make sense if an internal decision was made and understood. In 1897, inside the New York County Clerk's office at the Hall of Records, an administrative meeting took place that was not scheduled on the public calendar and not entered into a formal minute book. It was described later in neutral terms, an off-record discussion, because its purpose was not to resolve a legal dispute on paper. Its purpose was to decide how a sensitive record would be treated before it ever acquired the protections and liabilities of public registration. Three roles converged. The first was the Chief Deputy County Clerk, acting as the operational authority over what entered the register and how the office would defend its indexing. Integrity. The second was a court-appointed trustee, present not as a litigant, but as a fiduciary whose job was to keep an estate intact and predictable. The third was counsel from a law office tied to the property, an attorney who did not need to argue in open court if the machinery could be adjusted quietly in advance. None of these roles required conspiracy. They required alignment around a single practical question. What happens when a name, tied to inheritance and identity becomes contestable the moment it is made searchable. The record-keeping dilemma was technical on its face. A sensitive entry had surfaced, linked to property, trusteeship, and legal identity, at a time when indexing practices were being standardized and tightened. The office could treat it as a normal inscription, assign it a protocol number, and place it where any determined researcher could retrieve it. Or the office could treat it as a matter of preservation and maintenance, a phrase that carried institutional legitimacy without inviting explanation. The language mattered. In administrative environments, the safest interventions are those described as caretaking rather than judgment. The action that followed the meeting was not framed as censorship. It was framed as classification. The Chief Deputy's verbal instruction, later reflected indirectly in how clerks handled cross-references, was to mark certain inscriptions as non-entered and to keep their supporting traces outside the public-facing sequence. The justification was presented as technical, to protect the index from duplication, to avoid contaminating the central register with entries that could be misread, and to keep maintenance materials cleanly separated from what the public had a right to request. There was no written memo, because a memo would itself create an object that could be demanded, subpoenaed, or discovered. Instead, it was handled as office practice, a verbal order delivered within the chain of authority and absorbed into clerical routine. What did non-entered mean in practice? It did not mean the matter vanished. It meant it was routed. The entry could be acknowledged internally, referenced, tracked, and even used as a guide for trustees and council, without being granted the status of an official protocol-numbered reality. Clerks were instructed, through handling rather than doctrine, to do three concrete things. First, when a name or identity question arose that risked pulling inheritance and legitimacy into open contest, they were to avoid assigning a central protocol number until instructed otherwise. Second, if a cross-reference was unavoidable, they were to direct it toward internal materials, maintenance ledgers, secondary reference sheets, or an auxiliary index rather than the main register. Third, if an older reference already existed, it was to be treated as a preservation note, a term that implied harmless documentation while quietly denying the public an accessible pathway. This is where the decision becomes visible as a mechanism rather than an allegation. A system cannot create a parallel category by accident. It can only do so by intention and repetition. The 1897 intervention did not require that anyone forge a book. It required that the Chief Deputy authorize a category non-entered and that a trustee and attorney accept it as the safer outcome. Once accepted, the category did what the law allowed it to do. It shaped proof. The consequence was immediate and real, because inheritance is proof-driven. If a name is not in the central register, the burden of establishing standing increases sharply. A claimant who cannot be retrieved through official index logic must rely on peripheral references, which courts treat cautiously. Time stretches, costs rise, trustees retain control longer, and the public narrative, so important in the Gilded Age, remains clean. A sensitive identity question can be handled as administrative, and administrative handling rarely becomes newsprint. In that sense, the 1897 decision was not an act of disappearance. It was an act of preemption. It prevented certain disputes from acquiring the oxygen of official recognition. The trustee did not need to win a headline case if the record never granted the challenger a stable target. The law office did not need to argue legitimacy in public if the clerical pathway quietly refused to crystallize the issue into an official entry. The county clerks office did not need to justify discretion if it could say, truthfully, that the central index was complete as maintained. The decision also created a subtle discipline inside the office. Clerks learned what could be registered without consequence and what required handling. They learned that some names should be visible, protocol numbered, and easy to retrieve, while others should remain acknowledged only through controlled references. This is how a verbal instruction becomes a practice. Not through one dramatic act, but through the repetition of small, consistent choices. What gets numbered, what gets redirected, what gets treated as maintenance, and what gets left without an official foothold. Years later, when a stray index leaf appears with 2 columns, official entry and non-entered private, it reads less like an invention and more like the downstream documentation of a decision that began as speech. A clerk in 1897 would not have called it a parallel system. They would have called it proper handling. But the effect is the same. What does not enter the central register does not exist in the way the law can easily recognize, contest, or overturn. By the end of 1897, the meeting itself was gone, as such meetings usually are. What remained were behaviors, a sensitivity to certain names, a preference for routing rather than numbering, an internal vocabulary that softened judgment into caretaking. And in a building designed to transform paper into reality, the smallest vocabulary shift can become a boundary line. The image that closes this step is concrete and unremarkable. A clerk's hand in a back office at the Hall of Records, sliding a thin reference sheet into a box of maintenance ledgers instead of binding it into the public register. An action that resolves nothing publicly, yet prepares the next change that will be visible only in what the official books no longer show. Between 1897 and 1899, the change did not announce itself as a policy shift. It arrived as workflow, as a revision in the way names were carried forward from one book to the next. Inside the Hall of Records, the public saw counters and orderly ledgers. Behind that, the Records Index Unit treated the register as something that had to be kept clean, consistent, and maintained. Those were the terms that justified almost anything because they sounded technical. In practice, they defined what could be found. The alteration began with re-indexing. The Index Unit was responsible for translating raw filings into retrieval, name, property, reference, cross-reference. If a deed, trustee notation, or probate-related instrument contained identifiers that were considered sensitive, the decision made in 1897 could now be implemented without drama. It required no courtroom outcome. It required a clerk to choose how an entry would be represented inside the system that made it searchable. In 1898, as New York entered the consolidation era, when municipal administration expanded and standardized across the newly consolidated city, the appetite for uniformity increased. Uniformity is often described as neutrality, but it has a practical effect. It rewards what fits and suppresses what complicates. For the Index Unit, complication was anything that could invite dispute around inheritance and identity. A name that carried potential contestation was not treated as false. It was treated as hazardous to the index's stability. Hazardous material in an index is not argued with. It is contained. The concrete action that followed was a targeted re-indexing of names and properties, paired with the quiet removal of certain public-facing cross-references. Entries that had once pointed outward, linking a property description to a name or a name to a trustee, were adjusted so that the link no longer existed in the central lookup pathway. The filing itself could remain intact in the stack. The deed could remain recorded. What changed was the bridge that allowed an outsider to connect one document to another quickly and confidently. This is how a record can be altered in the real world without altering the paper that created it. The index unit did not need to tear out pages, it needed only to rewrite the map. The surviving traces of that rewriting are subtle but consistent with the mechanics of indexing. A ledger update appears in the internal sequence, an update that uses codes where the public index would normally use full names. In place of a surname, a clerk enters initials. In place of an identifiable person, a clerk enters a numeric reference that functions only inside a closed system. This is not the language of court decisions. It is the language of internal tracking. It allows a clerk to retrieve the correct file without granting the public a stable identity anchor. The rewritten ledger does not explain itself. It does not say, "This was changed." It does not confess to a practice. It presents itself as maintenance, a correction, a refinement. But maintenance is not neutral when it substitutes a name with an initial. An initial is not a person. It is a placeholder that signals to insiders while denying outsiders the ability to establish standing by simple search. At the same time, access to the special index book becomes physically restricted in a way that resembles an archival wing being sealed, not with bricks, but with procedure. The book is not destroyed. It is placed in a controlled room within the archive space, separated from the public request flow. Consultation requires internal permission. Retrieval becomes a matter of knowing whom to ask and what language to use. The effect is the same as a locked door in a public building. The space exists, but it exists for someone else. The decision is implemented through small acts. A clerk reclassifies a reference as non-entered, then routes it away from the central register. Another clerk updates a cross-reference line so it points to a code, rather than a name. A supervisor confirms the practice using the vocabulary of preservation and maintenance, which makes the change sound like protection rather than control. These actions accumulate until a pattern is created. A pattern, once created, becomes the rule that future clerks follow without ever being told why. The alteration also reshapes how property and identity can be proven. When names lose their public cross-references, proof becomes indirect. The connection between a person and a property no longer lives in one clean chain of entries. It must be inferred through trusts, powers of attorney, holding vehicles, and trustee signatures that function as proxies. This is not unusual in elite finance. What changes here is that the indirect path becomes not merely a preference, but the only accessible path. The individual's linkage to wealth can still exist in practice, income distributed through trustees, ownership held by arrangement, but the visible index stops acting. As an easy entry point for outsiders to challenge it, that is the consequence that matters. The shift does not eliminate assets, it stabilizes them. It reduces the risk that a contesting name can walk into the Hall of Records, request the right book, and emerge with a clean retrieval path that forces a public dispute. Without cross-references, a challenge becomes slower and more expensive. The burden of proof becomes heavier. The advantage tilts toward those already holding control through trusteeship and legal counsel. None of this requires a dramatic cover story. It requires only that the index, the public-facing map, becomes less literal. The official record remains complete in the sense that filings exist, but the system that translates filings into public knowledge becomes selective in what it makes legible. This is why the alteration is not merely clerical, it is structural. In a world where legitimacy depends on what can be proven quickly, the index is not an accessory. It is the mechanism that determines whether a person can be made real in legal time. The change from name to initial, from public cross-reference to internal code, is a change in legal weather. It decides what claims conform and which ones dissipate before they reach court. A clerk in that period would not describe this as erasing someone. The language would be administrative. Avoid duplication. Preserve integrity. Keep the index consistent. But the outcome is measurable. A name that appears in peripheral trustee materials without a protocol link cannot function as a stable point of contestation. It becomes a shadow in the paperwork, present enough for insiders, insufficient for outsiders. Could a cut in indexing be more powerful than a sentence? By 1899, the practice has a quiet completeness. Certain properties can still be traced, but only if one already knows the secondary pathways, the trustee name instead of the beneficiary, the holding entity instead of the household. Name, the power of attorney, instead of the marriage record that would anchor legitimacy. The central register remains respectable and orderly. The system has not lied, it has arranged. The alteration also produces a subtle institutional defense. If questioned, the office can point to procedure. It can say the index is maintained according to standard practice. It can treat missing cross-references as technical matters, not as choices. And because the changes were implemented through routine, ledger updates, re-indexing passes, controlled access, there is no single document that exposes the decision as a decision. What remains at the end of this segment is a changed environment. The Records Index Unit has created a two-tier reality. One tier that can be retrieved openly, and another that can only be navigated through internal codes and restricted books. The tension does not resolve into a confession. It resolves into a system that now behaves consistently with its own hidden logic. The final image is concrete and procedural. A narrow archival room off the main flow, a cabinet with a key, and a bound volume marked as a special index resting behind controlled access, while a public clerk's desk outside continues to stamp and file as if the map has never been redrawn. By 1901, the architecture of advantage was complete. What had begun as a clerical choice and matured through indexing practices now expressed itself in outcomes that required no explanation. The beneficiary did not need to be named in public because the system had already decided how recognition would flow. In the probate sequence that followed the final reconfiguration of the estate, the primary heir emerged as the only figure whose standing could be retrieved cleanly, quickly, and without qualification. The record of that year does not read as a victory, it reads as closure. Filings move through the surrogate's court with a notable lack of friction. Titles consolidate. Trustee accounts align. The estate's administration shifts from a phase of uncertainty to one of steady management. What changed was not the amount of property, but the certainty attached to it. Certainty is the currency that matters when inheritance crosses from family matter to institutional fact. The concrete action that marks this transition is redistribution, quiet, formal, and final. Assets that had been referenced through a mix of names and peripheral notes are now held through trusteeship in a standardized configuration. Deeds are reissued to entities rather than individuals. Rights of control are exercised by a trustee whose authority is unchallenged because the record no longer presents an alternative claimant with a usable path. The estate management company associated with the holdings assumes operational control, translating ownership into rents, maintenance contracts, and investment decisions that require no public justification. This is how benefit appears in the documentary. Trail. The recognized heir does not receive a dramatic windfall, they receive stability. Their legitimacy is not argued, it is assumed. Every document that matters retrieves their position without hesitation. Where earlier references once branched outward, now they converge. The beneficiary's name, or more often the entity acting on their behalf, appears in the places that count: trustee reports, consolidated title summaries, and the court's final approvals. What makes the benefit decisive is not accumulation, but insulation. By 1901, the system no longer needs to exclude anyone actively. It only needs to function as designed. The invisible party, whose existence can still be inferred through indirect materials, lacks the procedural leverage to intervene. Without a central index presence, contestation becomes theoretical. Legal time favors those who can be found easily. The beneficiary can be found instantly. The trustee's role is central here. Acting under fiduciary duty, the trustee executes transfers that align with the recognized structure of the estate. This is not favoritism, it is compliance. Trustees follow the record because the record defines their authority. If a claimant does not exist in that record, the trustee has no mandate to accommodate them. Silence becomes a justification, not a gap. The estate management company completes the process by professionalizing control. Properties are no longer framed as family holdings vulnerable to dispute. They are treated as assets under management. Leases are standardized, revenues are aggregated, decisions are made by policy rather than preference. This shift matters because it removes human narrative from the equation. Assets administered by entities do not invite questions about lineage. They invite questions about performance. The consequence for the invisible party is equally concrete. They lose standing without being told they have lost it. There is no denial letter, no adverse judgment. There is simply no door to knock on that opens quickly enough to matter. Any attempt to assert a claim must now overcome layers of trusteeship and entity ownership, each requiring proof that the index no longer supplies. The cost of challenge rises beyond practicality. Time does the rest. Socially, the beneficiary gains more than property. They gain continuity. Their position appears uncontested, their reputation unblemished by public dispute. In the Gilded Age, this mattered as much as money. Newspapers report stability. Philanthropic gestures proceed without footnotes. The absence of controversy becomes part of the family's public image, reinforcing the idea that the outcome was natural. Institutionally, the benefit validates the earlier choices. The system sees that its handling produced order rather than scandal. No hearings erupt, no editorials demand reform. The machinery worked. When systems appear to work, they are rarely questioned. The silence rewards itself. It is important to note what did not happen in 1901. There was no erasure of a person from memory. There was no destruction of files in bulk. The benefit accrued through alignment, indexing that favored one pathway, trusteeship that recognized only that pathway, and management structures that converted recognition into permanence. The invisible party may still exist in letters, in marginal notes, in family recollection, but those forms of existence do not move property. By the end of that year, the beneficiaries' advantage is no longer contingent, it is embedded. Any future review will encounter a clean surface. Trustees in control, entities in title, a recognized heir whose legitimacy requires no defense. The system has done what systems do best. It has made the outcome appear inevitable. The image that closes this phase is administrative and complete. A final probate ledger stamped and closed in 1901, a trustee's signature aligned with an estate management seal, and a chain of ownership that now runs smoothly forward, leaving behind without remark those who no longer appear in the books that decide who is allowed to matter. Between 1902 and 1908, the system completed what it had prepared. The disappearance did not occur as a single act, but as a sequence of small removals, each defensible on its own, together producing an absence that could no longer be reversed. By the time the period closes, the individual at the center of the earlier ambiguity no longer exists in the places where existence could be proven. The first trace to go is the easiest to overlook. In 1902, a routine pass through the county index removes a secondary reference that had once pointed outward. It is not crossed out with emphasis, it is simply not carried forward when the index is recopied and consolidated. Indexes are living instruments. They are rewritten to correct errors, align formats, and retire obsolete cross-references. When a name does not migrate from one iteration to the next, it does not register as deletion, it registers as housekeeping. At roughly the same time, property-related traces begin to thin. In the registry of deeds, filings that once allowed a reader to infer a personal connection to a parcel now terminate at entities and trustees. The deeds remain. The ownership does not vanish. What vanishes is the line that would have tied a human name to the property in a way that could be followed without internal knowledge. The registry still functions. It simply points elsewhere. This is a concrete action, not an implication. A name that appeared in auxiliary books supporting ledgers, working indices, or reference sheets ceases to appear in newly produced volumes. Clerks updating the books do not mark the absence as a correction. They treat it as alignment with the primary register, which by this point no longer recognizes the individual as an official entry. The logic is circular and effective. If the central book does not list the name, the auxiliaries should not either. By 1903, the disappearance spreads beyond legal instruments into the public record's softer edges. Social registers and city directories, which often draw from official data and voluntary submissions, no longer carry the name. This absence is not announced. It appears as a blank space where a line might once have been. In an era when social visibility reinforced legal legitimacy, such omissions matter. They signal to editors and compilers that a figure is no longer relevant or no longer safe to include. Obituaries offer no correction. If death occurs, it is recorded without prominence, or it is recorded elsewhere under institutional labels rather than personal narrative. The absence of a formal obituary is not proof of intent, but in the context of elite families and managed estates, it is conspicuous. Public memory relies on publication. Without it, the individual story does not circulate. Inside the administrative machinery, a more explicit act occurs. A small notation appears in an internal log, undated but consistent with practices from 1904. Correspondence disposed. The phrase is economical. It does not describe content. It does not justify the disposal. It merely confirms that letters once existed and no longer do. No copies are preserved. No abstracts are attached. The correspondence is treated as material whose retention is unnecessary to ongoing administration. This is the most literal disappearance in the sequence. Letters carry voice, intent, and dispute. They are dangerous in ways ledgers are not. Their destruction does not require a formal order. It requires only a judgment that they are no longer required for reference. Once disposed, they cannot complicate future readings of the file. What remains are neutral instruments, payment records, trustee instructions, and accounting notes that speak in numbers rather than names. The consequence of these actions is cumulative and real. By 1905, the individual exists only as a functional presence. Payments continue, but they are routed through powers of attorney. Instructions are executed, but they are issued by trustees. Notes appear in accounting books, but they identify accounts, not people. The system acknowledges an economic reality while denying a legal identity. This is not an error. It is an outcome. The law responds predictably to this configuration. Without a retrievable identity in the county index or a personal anchor in the registry of deeds, standing collapses. Any attempt to assert a claim must now rely on inference rather than proof. Courts do not operate on inference, they operate on entries, numbers, and names that can be pulled on demand. The absence of those elements is decisive. Socially, the disappearance completes the insulation begun earlier. There is no figure to discuss, no name to contest, no narrative to challenge the estate's settled order. The silence becomes self-reinforcing. Journalists have nothing to cite. Compilers have nothing to include. The public image of continuity remains intact. Institutionally, the system benefits from the clarity of absence. Files are easier to manage when they contain fewer volatile elements. Indexes are more stable when they point to entities rather than individuals whose legitimacy might be questioned. Trustees can act without hesitation when no alternative claimant appears in the books that authorize action. It is important to mark what has not happened. There is no dramatic expungement. No record bears the mark of erasure. The disappearance is achieved through omission, non-renewal, and disposal, each an accepted administrative act. Together, they accomplish what a single, overt deletion might not: a clean surface that does not invite inquiry. By 1908, the process is complete. The individual's name does not appear in the county index. It does not appear in auxiliary books. It does not appear in the registry of deeds as a personal holder of property. It does not appear in social registers or prominent public notices. What remains are traces that require prior knowledge to interpret: a trustee's signature, a coded account, a payment routed through an instrument that names no beneficiary. The real consequence is existential within the law. The person has not been declared non-existent, they have been made unfindable. In a system where reality is established by retrieval, unfindable is a terminal condition. The image that closes this stage is precise and quiet. A catalogue drawer opened in 1908, its cards aligned and complete. The space where a name once appeared filled not by a blank, but by nothing at all. While elsewhere, a ledger records a transaction without ever saying who it is for, preparing the ground for the next phase, where absence is no longer an event but a condition. In 1913, the story stops behaving like a clean administrative sequence and starts showing seams, not because someone confesses and not because a lost name suddenly reappears in the county index, but because another branch of government keeps counting what the central record refuses to name. Property can be hidden in an index, but it cannot be hidden from valuation. A city can forget a person on paper, but it cannot forget a taxable parcel. The inconsistency surfaces in the files of an estate valuation office, where tax assessment records are built to answer a different question than the county clerk's books ever tried to answer. The clerk's office exists to certify and retrieve. The assessment apparatus exists to measure and collect. It is indifferent to reputation, and it is not designed to preserve social peace. It wants an owner, an address, an assessed value, and a chain that makes sense to an auditor. And that is precisely why the record begins to betray itself here. The concrete action that reveals the break is comparison. In 1913, a reviewer working through tax rolls notices a mismatch that cannot be explained by ordinary transfers. A property that has been administered continuously, no visible foreclosure, no public litigation, no obvious sale, now appears in assessment material under an entity designation that does not align with the public-facing index logic. The entry does not read like a simple trust name that any clerk could retrieve through standard cross-references. It reads like a holding label, a managed identity. the kind of designation that exists to function rather than to be understood. The assessed value is substantial enough that it cannot be dismissed as a clerical scrap. It is a real asset, measured and recognized by the city's revenue machinery. When that reviewer traces backward, the chain should be straightforward. A tax roll entry should connect to a deed reference. A deed reference should connect to the county index. The county index should lead to a protocol number and a retrievable name. In normal cases, the path may be long, but it is stable. In this case, the chain breaks at the point where a person should appear. The deeds still exist. The registry of deeds still shows instruments recorded for the parcel. Trustee signatures still appear where they would be expected in managed estates. On paper, ownership has been administered. The estate management company, already present in earlier phases, has left enough operational traces to confirm continuity. Maintenance disbursements, legal fees, routine filings that imply an ongoing hand on the wheel. Nothing about the asset's life suggests abandonment. And yet, when the deeds are cross-checked against the official index, the county index logic that should reveal who counts, the personal anchor is missing. Where a surname should appear as the legal spine of the chain, there is either an entity that cannot be cleanly decoded through public references or an absence that forces the reader to leave the official pathway entirely. This is not a matter of a single entry being hard to find. It is systemic. In 1913, tax assessment records. The property is treated as unquestionably real and continuously controlled. In the deeds, the property is treated as legally transferable and properly recorded. In the central index, the human identity that would make the story ordinary is not there. The document trail does not collapse into nothing. It collapses into abstraction, trustees, entities, codes, and cross-references that never resolve to the person whose existence would make contestation possible. The inconsistency tightens. When valuation documents are examined for ownership attestations, assessment offices, especially when values are high and disputes are possible, often rely on affidavits or internal certifications to confirm who is responsible for notices, appeals, and tax liabilities. In the 1913 file set, one such certification appears in a form that should be routine. It carries the language of administrative certainty, the kind that makes an auditor comfortable, but the signature line is wrong. A clerk's signature appears where a trustee or an authorized agent of the estate management company should normally sign. The name is not flamboyant. It is not framed as a special authority. It is simply positioned in the wrong place, performing the wrong function. The document effectively implies that an indexing or recording official is attesting to a property linkage that should be certified by the party administering the estate. That does not happen by accident in a stable system, because it creates a liability. If a clerk signs as if they were an authorized signatory for ownership certification, the clerk becomes part of the chain. And if a trustee is supposed to sign but does not, the file reveals an avoidance, an effort to keep the attestation away from the party whose signature would invite questions about who stands behind the entity name. The displaced signature is not proof of a single person's intent. It is proof of institutional improvisation. It suggests that somewhere between the evaluation office and the record system, someone needed the file to be complete without inviting the wrong form of scrutiny. A trustee's signature would have anchored the document to a fiduciary relationship that could be questioned. An estate management signature would have exposed the operational structure and, by extension, the beneficiary chain. A clerk's signature, by contrast, carries administrative neutrality. It feels like handling. It closes a loop without opening a new one. This is where the parallel reality becomes visible, not as a theory, but as a practical contradiction. The city's counting mechanism recognizes the asset and demands accountability for it. The deed mechanism recognizes the instruments and records them. The indexing mechanism, which controls legal visibility, refuses to provide a human identity that can be retrieved and challenged. Three systems agree that the property exists. Only one system behaves as if the person behind it must remain unfindable. The consequence is not merely clerical embarrassment, it is legal structure. If a claimant cannot be located in the central register as a proper party, if the chain does not resolve into a name that can be summoned, served or contested, then the property's control becomes effectively immune to ordinary challenges. A rival heir cannot easily force a hearing if the identity they need to contest cannot be pulled from the official books. A journalist cannot easily write a clear narrative if the public-facing chain stops at entities and initials. Even a court moves slower when the record's spine is missing. The asset remains taxable, transferable, and managed, but it becomes unusually resistant to disruption. The inconsistency also exposes something else. The system's need to patch itself. A parallel arrangement can function smoothly as long as each part stays within its lane. The moment assessment records demand clarity, the hidden structure has to interface with public administration. That interface creates friction, and friction produces mistakes. The displaced signature is one such mistake, a small deviation that exists because the file had to be complete enough to pass through a revenue process, while remaining incomplete enough to prevent the wrong kind of retrieval. If the numbers exist, why doesn't the person exist? That question is not philosophical here, it is documentary. The assessed values are written down, the parcels are identified, the tax liabilities are allocated. The city treats the property as real, continuous, and collectible. The deeds treat it as lawfully recorded. The index treats the human anchor as optional, or as something that must be displaced into code. In 1913, the record does not fail entirely. It fails precisely at the point where contestation would become possible. By the end of this segment, the investigation has advanced in a way that cannot be dismissed as mood or atmosphere. A chain has been tested across separate systems. It holds through assets and values, and it breaks at identity. A signature appears where it should not, suggesting a deliberate shortcut to keep a loop closed without exposing who stands behind it. The system is still functioning, which is why the inconsistency matters. It is not a collapse, it is a controlled strain. The closing image is concrete and unresolved. A 1913 assessment page with an assessed value neatly entered beside a property description, a stamped certification at the bottom, and a signature sitting in the wrong place, clean ink on official paper, quietly preparing the next question, because if this mismatch had become visible to the wrong audience at the wrong time, the cost would not have been technical. It would have been public. Between 1910 and 1920, the problem stopped being merely clerical. It became reputational, financial, and political at once, because the city's public narrative depended on the belief that wealth was orderly and that records were neutral. By then, the estates involved were no longer private family matters. They were interlaced with banks, trust departments, philanthropic boards, and the social architecture that held respectable New York together. If the selective registry practice became visible in that decade, it would not have produced a single lawsuit. It would have produced a cascade. The risk begins with the press, not because newspapers were omniscient, but because the press was the point where private disputes became public. Interpretation. In those years, a story that implied an estate had been stabilized by a quiet manipulation of public visibility would not read as a technical irregularity. It would read as privilege operating through government machinery. And in the 1910s, when progressive-era skepticism toward concentrated power was growing, that kind of story had traction. It could be framed as a corruption of records, a betrayal of civic transparency, and an example of how the elite insulated themselves from ordinary rules. The exposure risk also intensified because the city's financial system had become more formalized around trusts. Bank trust departments were no longer boutique operations. They were institutional pipelines, holding and managing assets that influenced credit, development, and market confidence. If a major holding arrangement was suddenly contested because a claimant could demonstrate that an identity had been administratively suppressed, the banks involved would face more than embarrassment. They would face uncertainty in title, challenges to fiduciary conduct, and potentially a run of disputes that could force revaluation of collateral. This is where the 1913 scheme matters. A valuation record that counts an asset while the central index refuses to name the human anchor is not just an oddity, it is a vulnerability. It creates a crack that a determined party could widen, especially if an attorney could show that the crack benefited a recognized heir and disadvantaged a suppressed claimant. The issue would not stay within the county clerk's office. It would spread into tax offices, trust departments, and the court's own credibility. So containment becomes the rational response, not as a dramatic conspiracy, but as a series of legal and social actions that reduce the chance the crack becomes a case. The first containment method is procedural delay. If inquiries arise, whether from a challenger, a journalist, or even an internal reviewer, the system responds with friction rather than refusal. Requests are routed, paused, or redirected toward offices that cannot answer them cleanly. A record is under review. A file is in off-site storage. An index reference is not located. These phrases do not deny the existence of material. They postpone access until momentum dies. In a world where legal action depends on timelines and resources, postponement is often enough. The second method is legal narrowing. When sensitive matters threaten to become public, counsel can steer disputes into private settlement frameworks. Agreements are reached without admission. Claims are addressed through compensation, confidentiality, or reallocation of minor benefits that preserve the main structure. Courts can be petitioned for protective handling of certain filings, requests to limit dissemination, to seal attachments, or to treat correspondence as non-essential. Even when formal injunctions are rare, the threat of litigation can deter publication and intimidate weaker challengers. The result is not silence by force, it is silence by cost. The third method is social containment, which in the 1910s was as powerful as any court order. Elite families were tied together through marriage alliances and shared institutional roles. A contested estate could threaten more than money. It could threaten the reputations of multiple households at once. Marriage between families did not just merge names, it merged liabilities. If an invisible claimant became visible in court, the story could attach itself to in-laws, trustees, and board members who had built their public identity on civic virtue. This is where philanthropic structures become part of the risk calculus. Donations to hospitals, museums, and civic projects were not purely altruistic. They were reputational architecture. Boards were staffed by the same names that appeared in trust documents and property chains. If a scandal suggested those names had relied on selective record-keeping to maintain control, the philanthropic ecosystem could be dragged into the narrative. Institutions would face pressure to distance themselves. Donors would face scrutiny. Rival factions could use the scandal to reshape influence. Local political figures are implicated by proximity, even without wrongdoing. The county clerk's office is a civic organ. If the press framed selective indexing as a practice tolerated or quietly enabled by local administration, the story could become political ammunition. Reformers could demand inquiries. Opponents could claim favoritism. Even the suggestion that a public index could be managed to favor private interests would trigger calls for oversight. Political actors in the city, sensitive to public mood, would prefer the matter to evaporate rather than crystallize. Market risk follows naturally. If the estate's assets included prominent parcels or interests that touched development and lending, a contested chain of title could chill. Transactions. Properties might become harder to sell or refinance. Titles could be clouded. Trustees could face demands for accountings. Banks could tighten terms. In a city where real estate value is tied to confidence, the mere possibility of legal contestation can reduce liquidity. It does not require a verdict. It requires uncertainty. This is why the selective registry, however ethically questionable, can be defended internally as stability preservation. The system can persuade itself that it is preventing chaos. If visibility triggers a contest, and a contest triggers headlines, and headlines trigger board resignations, litigation, and market hesitation, then limiting visibility becomes, in institutional language, a form of risk management. The phrase does not need to be spoken, it is embedded in the behavior. What makes the 1910 to 1920 period especially dangerous is the historical environment. The city is modernizing. Reform movements are pressing against old arrangements. Public trust in institutions is contested. A story that combines elite inheritance, government record-keeping, bank trusts, and concealed identity is not a family scandal. It is a narrative about the legitimacy of the system itself. That is why even indirect intimidation becomes plausible, not threats in the street, but quiet signals. A lawyer's letter, a warning about defamation, a suggestion that a claimant's future employment or social standing could suffer. These are not cinematic gestures. They are realistic tools of social discipline in a closed world. The consequence is that silence becomes mutually beneficial. The recognized heir keeps stability. Trustees keep their authority intact. Banks avoid title uncertainty and reputational exposure. Political figures avoid inquiries. Philanthropic institutions avoid scandal adjacency. Even the clerk's office avoids scrutiny of its internal practices, which would be difficult to defend in open daylight. By the end of the decade, the risk has shaped behavior into a kind of disciplined quiet. The record remains selectively legible. The public surface remains clean. The cost of disturbing it remains high enough that most people will not try. The closing image is not a courtroom. It is a newspaper desk in the 1910s, a draft story held back, a lawyer's note attached, and a file returned to a cabinet, because in that decade, the most effective containment was not proving something false. It was ensuring it never became printable. 1926. The story no longer depends on a single family, a single trustee, or a single sensitive name. The system has learned from the risk. What began as selective handling becomes institutional habit, and habit becomes policy without ever needing to declare itself as such. In the Hall of Records and its adjacent record environments, the silence is no longer a response to a specific threat. It is the default setting. The shift is visible in the language used to manage access and describe gaps. Where earlier phases required careful routing, non-entered, private, coded, by the mid-1920s, the vocabulary is smoother and more defensible. Files are restricted. Materials are maintenance. Certain volumes are under preservation. These terms sound neutral, even responsible. They do not admit to concealment. They imply stewardship. And because they imply stewardship, they reduce the pressure to explain why an item cannot be produced. This is the function of what we can call an archival Preservation policy, not as a single printed decree pinned to a wall, but as a routinized framework of classification and retrieval. By 1926, access is no longer organized around whether something is true. It is organized around whether something is for the public. That distinction is practical and it is easy to expand. Once an office accepts that some books exist for internal continuity rather than public inspection, it becomes natural that those books may not appear in a catalogue designed for the public. The concrete action that marks normalization is standardization. Routines are formalized in the day-to-day management of records so that the earlier anomalies stop looking like anomalies. Auxiliary books become a recognized category. Internal indices become legitimate tools. Not everything that is used must be listed. Not everything that is listed must be directly accessible. The logic is administrative. Public access is a service, not an entitlement to the full structure of the system. A clerk in 1926 does not need to be told about the origin story. They only need to be trained in procedure. They learn that certain ledgers are not requested at the front desk. They learn that a special index may be consulted only under supervision. They learn that if a cross-reference points to an internal code, the correct response is not to decode it publicly, but to route the inquiry to a supervisor. They learn, in other words, how to keep the machinery intact. The public-facing result is deceptively simple. A researcher approaches the counter with a question. The office consults the main index, produces what it can, and treats anything beyond that as either unavailable or outside scope. The explanation does not have to sound adversarial. It can sound procedural. The requested material is not in the public catalogue or held for preservation or restricted due to maintenance. The researcher may suspect obstruction. The office can claim standard policy. This is how secrecy becomes routine. It is no longer a secret, it is a category. The policy language also solves an institutional problem created by earlier improvisations. In the early phases, the system had to reconcile internal knowledge with external access. That reconciliation created seams, misplaced signatures, broken chains, coded references visible in unexpected places. Normalization reduces seams by making the internal tier officially normal within the institution, even if it remains unofficial to the public. Once internal books are accepted as part of normal archival practice, their existence stops producing internal anxiety. Clerks no longer fear that the mere presence of an unlisted ledger is suspicious. It is simply how the office is run. In 1926, maintenance becomes especially useful because it covers both time and intent. A ledger can be under maintenance indefinitely. A book can be being preserved without a clear timeline for return. This is not necessarily fraud, it is an access technology. It allows an office to delay without appearing to deny. It allows gaps to persist without being described as gaps. Over time, it trains the public to accept the idea that not everything is immediately retrievable, even in a building dedicated to retrieval. The consequence is structural. The system begins to protect the method, not only the case. Earlier, the point was to stabilize a particular estate and prevent a particular contest. By 1926, the institutional behavior has broadened. The office has discovered that selective visibility reduces exposure across multiple categories of risk. Inheritance disputes, title challenges, reputational scandals, political pressure. Once that discovery is made, it becomes rational to embed it into policy routines, because routine is easier to defend than exception. This is also where culture forms. A culture of invisibility does not require malice. It requires incentives and repetition. Clerks are rewarded for preventing disruption, not for inviting it. Supervisors prefer clean counters and short lines, not extended debates about why a book is unlisted. Administrators prefer the absence of complaints. The public sees a functional office. Internally, the office maintains a separate tier of knowledge that operates under controlled access. Over time, staff turnover ensures that the original motive fades while the mechanism remains. People follow the procedure because it is procedure. And because it is procedure, it becomes difficult to challenge. A critic would need to prove intent, but intent is no longer necessary. The office can argue that its classifications are standard archival practice. It can cite preservation concerns. It can point to the complexity of records management. It can claim sincerely that not everything can be exposed to handling. The culture is insulated by the language of care. This normalization also changes the shape of what survives. Documents that were once volatile, correspondence, marginal notes, direct identifiers, are less likely to remain in accessible form. What persists are instrument-level traces, coded references, trustee signatures, entity names, and maintenance logs. These are durable because they are functional. They support administration while withholding narrative. They are exactly the kind of material a system preserves when it is protecting method over story. By the end of 1926, a researcher confronting the archive would encounter a new kind of barrier, not a locked door, not an overt refusal, but a calm institutional confidence that certain questions cannot be answered because the books that would answer them are not public. The existence of auxiliary ledgers is no longer shocking. It is expected by the people who work there. The tension resolves into routine. The archive does not deny the possibility of gaps. It incorporates them. And once gaps are incorporated, they stop looking like scandal and start looking like policy. The closing image is concrete and procedural, a stamped routing slip dated 1926, a request marked restricted preservation, and a clerk returning to the counter with a thin smile and a practiced line. While behind the public desks, an unlisted auxiliary book rests in its controlled room, preserved not only as a record, but as a habit. In 2026, the case survives not as a rumor, but as a problem of access. The city has changed, the building has changed, and the work has changed, yet the underlying rule remains intact. What cannot be retrieved cannot be contested. The modern promise is that digitization would dissolve this dynamic. Scan the ledgers, publish the catalogs, index the scans, and the past becomes searchable. But digitization does not automatically produce visibility. It produces a new kind of gatekeeping, one built from metadata, permissions, and the quiet decisions of what is worth converting into a public record. The present-day investigation begins the way so many do now, not at a counter, but inside a database. A researcher working from peripheral references and surviving tax and probate fragments tries to reconstruct the trail that the old index refused to hold. The focus is specific, the special index, the auxiliary logic that appears in cross-references but refuses to appear as a public object. In 2026, the researcher's first action is concrete and modern, tracking the phrase through digital catalogs, repository inventories, and scanned finding aids, looking not for the book itself, but for the way its existence would be described in the system's own language. Here, the problem reveals its continuity. The search yields results that suggest presence without producing retrieval. A catalog entry may acknowledge an internal index. A collection note may reference restricted material. A digitized series may list maintenance ledgers without item-level descriptions. The database does not say the special index does not exist. It simply does not expose it in a way that can be requested, downloaded, or verified. The same logic as 1897 appears in a different interface. The barrier is no longer a locked room. It is an empty field in a metadata schema. The researcher then attempts the second modern action: access requests that function like faux IA in spirit, even when the entity is not strictly federal. Requests to inspect non-public ledgers, to view restricted indices, to obtain item-level inventories. The reply, when it comes, follows the language that was normalized a century earlier: preservation concerns, restricted status, non-public series, materials not available for direct handling, a referral to archival policy. The vocabulary is restrained and procedural, which makes it difficult to argue against without appearing unreasonable. In 2026, the institution does not need to threaten anyone. It only needs to be consistent. The third action is technical rather than legal: tracing access logs and digitization. Workflows, looking for the shadow the special index would leave in a modern system. Digitization projects create records, even when the content remains closed: project IDs, scan counts, box-level tracking, internal notes about conservation and handling. A researcher can sometimes locate an object not by its content, but by the fact that it passed through a workflow. In 2026, that means searching for metadata anomalies, series with missing itemization, references that skip expected numbering, internal codes that appear in one catalog but not another. The goal is not to prove the book's contents, it is to prove the book's administrative existence, and yet the pattern repeats. The system yields partial confirmations without surrendering the object. A digitization initiative may list the Hall of Records series generally, but auxiliary books are treated as operational material rather than public heritage. A repository may preserve the scans, but restrict dissemination. A public interface may provide a clean narrative of the era, foundational civic memory, orderly administration, while the underlying retrieval architecture quietly maintains tiers of visibility. In the modern archive, invisibility is no longer achieved by removing a card from a drawer. It is achieved by leaving a dataset unindexed or by indexing it without exposing the keys that make it searchable. This is where the legacy becomes measurable. The families and institutions linked to the estate still possess what matters: consolidated holdings, stabilized titles, philanthropic narratives, and a public history that reads clean. Their story, recorded through published biographies, institutional histories, and curated archives, does not need to mention the missing identity. The official narrative is not necessarily false. It is simply incomplete in the way a controlled system prefers. It highlights what can be proven easily and ignores what would require unlocking auxiliary pathways. The unresolved element remains stubbornly specific. Why do certain names appear in peripheral documents, tax materials, trustee notes, accounting trails, maintenance references, while refusing to exist in the central register where they could be formally retrieved? In the digital era, that question becomes sharper, not softer, because the expectation of completeness is higher. If we can search everything, the absence looks less like an accident and more like a choice. But the institution can still answer the same way it answered in 1926, by citing policy: restricted preservation, not public, not indexed for external use. The consequence in 2026 is not merely academic. Indexing determines justice outcomes. Researchers cannot challenge a chain they cannot retrieve. Descendants cannot investigate legitimacy without the spine of official access. Journalists cannot responsibly publish claims without documents that can be verified. Courts, when they engage historical property issues, still rely on certified records. rather than inference. Even when scans exist somewhere, the difference between exists in storage and exists in access remains decisive. Modern technology also adds a new layer: algorithmic invisibility. Search results depend on standardized metadata. If a ledger is scanned but not OCR'd, it is effectively invisible to keyword search. If it is OCR'd but stored behind a restricted interface, it is visible only to the institution that controls the portal. If it is listed only at box level, it cannot be navigated by outsiders without spending weeks in cross-comparison. The system does not need to erase to deny. It needs only to avoid making retrieval efficient. So the present is not a triumph of transparency. It is a continuation of the same principle in a cleaner form. The special index may now exist as a digital object, a set of images on a server, a series flagged for internal use. But if the public cannot access it, the effect is unchanged. The record is still selective. The law is still shaped by what can be produced. The narrative is still guided by what can be proven quickly. In 2026, the most revealing feature is that the barriers are no longer personal. There is no chief deputy issuing a verbal order. There is no trustee quietly steering a clerk. There is only policy, workflow, and a system that protects itself by protecting how it decides what gets seen. The closing image is concrete and current. A modern archival portal on a screen, a search result that returns a series title, but no items, a restricted flag where a download button should be, and somewhere behind that interface, the same kind of book that once sat in a controlled room, now preserved in pixels, still deciding who can be found. In 2026, the most revealing moments are no longer found in the content of the archives, but in the infrastructure around them, the paperwork that governs how records move from shelf to scan, from scan to catalog, from catalog to public visibility. The researchers' next step is deliberately unromantic. Instead of asking for the special index itself, they ask for the administrative trace it would inevitably leave behind in any modern digitization program. Not the pages, the workflow. That means requesting project inventories, transfer lists, and metadata exports, the kind of documentation that exists even when access is denied. A FOIL-style request is drafted for digitization logs, box-level manifests, and any item-level identifiers generated during scanning. The response, when it arrives, is not a refusal to cooperate. It is cooperation shaped into safe boundaries, a summary table, an incomplete inventory, and a familiar phrase that appears beside certain lines like a quiet stamp. Restricted under archival policy, not releasable in full, not described at item level. The institution offers enough to appear transparent while preserving the one thing that matters, the ability to connect a label to a retrievable object. So the researcher changes method again. Instead of pursuing the restricted object directly, they pursue the cracks between systems. Municipal record ecosystems rarely live in a single repository. County clerk series, surrogates court holdings, municipal archives, contracted storage, and university-affiliated collections often share overlapping descriptions while keeping separate catalogs. In 2026, those catalogs are usually searchable, but not necessarily consistent. The researcher runs cross-comparisons between public finding aids and older microfilm guides, looking for discontinuities in naming. A series that once had an internal nickname may now be described as auxiliary index materials. A volume that once appeared as special may now be flattened into maintenance. The terms are not lies. They are protective translations, language that preserves function while removing specificity. The next concrete action is technical, pulling catalog data in bulk. Many repositories export EAD-style finding, aids, mark records, or simple CSV inventories. When you can't access a book, you can still inspect the architecture that describes it. The researcher downloads what is available and looks for gaps that have no innocent explanation. Numbering sequences that skip, container lists that abruptly switch from item level to box level, folder ranges that exist as placeholders without titles. In a world of standardized digitization, those transitions usually reflect policy. What is described precisely is intended to be retrieved. What is described vaguely is intended to be controlled. A second FOIL-style request is filed, this time for retention schedules and classification guidance connected to archival preservation routines. Not to accuse anyone, but to understand the vocabulary that decides visibility. The reply arrives with policy language that reads like bureaucratic weather. Guidelines about fragile materials, privacy constraints, donor restrictions, and the need to protect records from damage. None of it mentions the special index. None of it needs to. The effect is structural. Policy creates a category where an object can exist indefinitely without being publicly enumerable. Then comes the most modern barrier of all, authentication. In many digital portals, the difference between public and restricted is not a locked room, but a role-based permission flag. The researcher attempts to locate references to restricted series indirectly through cached search results, mirrored, finding aids or older copies of collection pages preserved by libraries. Sometimes a restricted item leaves a ghost in the open web, a dead link, a thumbnail that no longer loads, a citation that points to an internal identifier. The researcher compiles these fragments into a map of known unknowns, objects that appear to have identifiers but not access. The consequence of this work is paradoxical. The more modern the archive becomes, the easier it is to prove that something is being managed, and the harder it is to prove what it contains. Digitization creates administrative certainty while maintaining informational uncertainty. A restricted series can be verified as a line item, a budget code, a scanning count, a storage transfer, a server directory, yet remain inaccessible as evidence. The system evolves from secrecy into compliance. It can show its processes without surrendering its power. And the legacy remains intact precisely because the method now looks defensible. Families and institutions don't need to intervene in 2026. They don't need to send letters or make calls. The archive's own structure does the work for them. The public narrative stays clean because the materials that would complicate it are either flattened into vague categories or walled behind permissions that appear routine. Even a skeptical researcher must admit a practical truth. You can't publish what you can't verify, and you can't verify what you can't retrieve. By the end of this extension, the EI investigation advances in a way the 20th century phases could never quite achieve. It identifies how invisibility survives without anyone actively maintaining it. The mechanism is no longer a person. It is a metadata decision, a catalog boundary, a policy phrase that substitutes for explanation. In 2026, the record doesn't need to deny. It only needs to remain unqueryable at the point where identity would become actionable. The closing image is concrete and contemporary. A downloaded inventory file open on a laptop. Rows of series names and box counts marching downward, and one column, item title, blank wherever the most sensitive material should be, as the cursor hovers over a single word that has replaced a century of answers. Restricted. By the time we reach 2026, the most difficult part of this case is no longer the century that separates us from it. It is the simple fact that civil records do not merely describe reality, they produce it. A name that cannot be retrieved becomes a name that cannot be challenged. A relationship that cannot be indexed becomes a relationship that cannot be argued. And an absence that can be defended as policy becomes an absence that can endure for generations without ever needing to be explained. That is the institutional moral buried beneath the paper, the apparatus itself, the New York County Clerk's Office, its indices, and the archival policies that govern access, functions as a quiet form of power. Not the power of a single official, and not the power of a single family, but the power of a system that decides what counts as public, what counts as maintenance, what counts as restricted, and therefore what counts as real in legal time. Once that power is exercised consistently, it becomes almost indistinguishable from neutrality. People stop asking why a book is unlisted. They stop noticing when a chain of documents breaks precisely at the point where identity should appear. They adapt to the silence, and then they inherit it. The action that matters most is also the easiest to minimize: administrative exclusion. In 1897, a sensitive entry could be treated as non-entered under the language of preservation and handling. Later, the same logic could be encoded into routines that made auxiliary ledgers normal, but publicly invisible. And now, the same boundary can be enforced by metadata, permissions, and policy vocabulary that sounds responsible while it withholds the one thing research needs: retrieval. Nothing here requires a dramatic erasure to be permanent. A record does not have to be destroyed to stop existing. It only has to be kept outside the index that defines the public world. The historical consequence is measurable. Inheritance can consolidate without contest. Titles can stabilize without open scrutiny. Public memory can remain clean because the archive's structure prevents the messy parts from becoming legible at the speed required for challenge. The official narrative survives. Not because it is fully proven, but because it is fully accessible. Meanwhile, the person who survives only in peripheral traces, payments, powers of attorney, coded references, trustee actions, occupies a strange category: economically present, administratively useful, legally unreal. And that is why the case never needed a single decisive lie. It relied on something more durable: the reality that most people experience the past through what they can request, what they can download, what they can cite, and what they can put in front of a court or a newsroom without being dismissed. Technical accessibility is not the same as social accessibility. A truth can exist inside a restricted series and still be functionally unreachable. The distance between stored and available is not a clerical detail. It is where power lives. So the final question is not whether the book exists. It is what it means that a system can keep something technically preserved while making it practically untouchable, and call that stewardship. How many non-existent lives were required to protect the stability of the officials, and how many more are still held in that same administrative shadow, waiting behind the word restricted? The last image is simple and contemporary: a digital catalog page open on a screen, a series title visible, an item list missing, and a single access flag sitting where the evidence should be, quietly proving that the archive can preserve a truth while still deciding who is allowed to reach it.